Please be seated.
Okay,
we will continue with the summation of the defense.
Actually, sorry, the other front table. So where we left off was the video of the small garage fire and the timeline. It's this one, right?
left front.
Okay, so we're at 4:59 and 52 seconds. We're going to press play. And we just saw some movement at that top right portion of the screen, ladies and gentlemen. That is, do you want to back it up one more time? Just a few seconds. So I'll direct all of your attention to that top right corner. I think this was also to see, you could see a vehicle.
Yep.
Okay, so that would be the Porsche Cayenne. You can see it sort of going off the screen to the left, pulling into the street. And when the video continues to play for approximately another minute and 20 seconds, you'll see the flash from the fire. Right there. And we're stopping at 5:01, 28 milliseconds. Can I have the right table again, please? So, I don't know, ladies and gentlemen. I don't know how the state can allege that Paul Caneiro is in his vehicle with his family, pulled out on the street, and then there's a gas fire by the garage. There was testimony from, I think it was John Lightbody, who confirmed gas is highly flammable. He even gave like the exact temperature or something at which gas ignites. And it's not a slow burning substance. The moment you light gas on fire, it flames up. So, I don't know the explanation. And if the state comes up with one, I don't know if they will. Remember, ladies and gentlemen, it's not coming from the witness stand. And that's what I mean when I say a theory. That's what I mean when I say the state is theorizing or they're filling in the blanks or trying to fit the puzzle pieces in certain ways. There was no testimony from any witness in this case that
Judge, I object. Can I just be heard for a moment?
Yes, you can. Ladies and gentlemen, remember with all pieces of evidence, you are to determine what happens and what happened in this particular case. Is you are the sole fact finders in this case. The attorneys are absolutely allowed to comment on the evidence. However, you will make that final determination and you look at the evidence. And you'll also learn when I give you the law that you will also be allowed to make reasonable deductions based upon that evidence. But again, the attorneys are allowed to comment on the evidence. You determine on how you accept that information. Does everybody understand that?
Yes.
Okay. We'll continue with the summations of the defendant.
Now again, this ties into what was stated earlier about, are there two people? Where are they? It's dark out. What's happening? What we do know is at this moment, Paul Caneiro, and for that 1 minute and 20 seconds, is in the vehicle on the street with his family. We do know that he is not physically located at that garage when that fire started. We do know that Katie Caneiro said it was under a minute from the time that she saw her dad walking toward the garage and coming out of the car. The timeline doesn't make sense. Now another issue in this case is, where is Jennifer's phone? You heard testimony from Detective Miglarisi initially that there were multiple phone extractions performed in this case. And that included Paul's phone, it included Keith's phone, and Tiffany Rivera, and a variety of other people that were mentioned at the time. And I asked Detective Migliorisi, and I asked Detective Pedrozello, and I think Mr. Murray might have even asked Detective Vogt, where's Jennifer Caneiro's phone? And there was no 911 call placed from the house. You heard testimony from, I think it was Mr. Abraham, that said when the Verizon power is cut, you lose internet, you lose Wi-Fi, you lose power, but you don't lose cell service. Cell service isn't coming from inside of the home, it's coming from outside cell towers. So, again, I don't know what exactly they're going to say, but I do know that if this suggestion is that if one person is responsible for these murders, and Keith is murdered outside of his home, and there's gunshots that are heard 3 miles away practically, then we can imagine, by Dennis Corpora, then we can imagine that Jennifer Caneiro would have heard them too. And why was there no 911 call? Where is her phone? And more importantly, since we don't have her phone, why don't we have her phone records? I questioned Detective Migliorisi, I believe, and also Detective Pedrozello about that. And when I questioned Detective Migliorisi, who did the cell phone extractions, he was very informative. And he explained cell phone extractions are very helpful because there's a lot of information in them, right? You can get the content of all the text messages, you can get contact lists and phone logs and all sorts of data that people keep in their phones, their calendars, basically their lives. Now, without the phone, we can't access that information. But Detective Migliorisi confirmed what we can access with phone records is other limited information. Call logs, text message logs, not the content, but we can at least access who texted who and when, and cell site data. Cell site data tells us the general vicinity of where the phone is. Might not be an exact location, but it's a general location. It's a general vicinity of that phone. And why is this important? Because you heard testimony from Katie Caneiro that she continuously called Jennifer's phone because it was ringing. She said she called the house phone once and it went straight to voicemail. That's because the power was cut. She didn't bother calling it again because it wasn't working. She called Jennifer's phone repeatedly from the general time frame of 9:30 a.m. to noon, she testified. It kept ringing. Where was the phone? It was on somewhere. Why don't we have the phone records to know where? Was it in Colts Neck? Was it in a town outside of Colts Neck? Was it in a state outside of New Jersey? We just don't know. And Catherine Lachise testified that when she tried calling Jennifer at approximately closer to 12:31, she couldn't remember on the stand, but she confirmed that when she gave her statement at the time, it was off. So who turned the phone off? If people are calling and texting her, we would have records of that. We would have data. We would have cell information, cell site. Wouldn't we want to know that? Because Mr. Caneiro didn't have the phone. He didn't have the phone. Where's the phone? They searched him. They searched his house 3 times. Remember that testimony from Detective Catalona? First it was, they took photos on the 20th. Then they searched it on the 21st. 22nd was Thanksgiving, so they took a day off. They returned on the 23rd. They continued to search the home. And then they searched it again later that week. That Saturday on the 28th or something like that. They didn't find Jennifer's phone. He never left police custody that day. We know that. So, I would imagine in an investigation such as this one, where you have 7 years and 3 months to get phone records, that's something that maybe we'd want to know. And no investigation is perfect, ladies and gentlemen. Let me be clear. I'm not suggesting that the investigation needed to be perfect. I'm not suggesting that every little I needed to be dotted and every little T needed to be crossed, because that's not the reality of life, and we know that. But something more than what we have. Because not even wanting to know where Jennifer's phone is problematic. Because if Mr. Caneiro is at his home with first responders and the police from 5 in the morning until noon when he goes to the police station with his family, and there's cell site information that says the phone is elsewhere, that would be relevant. That would be important to know. And in case the state suggests, well, you know, maybe the fire burned up the phone. Well, I think that that could be called into question, and here's why. Number one, these are photos of things that were recovered from the rubble. You heard testimony that they tediously sifted through the debris. They piled it together and they sifted through it to see what they could find. And in the top left photo with cone number 14, you can see the knife across the screen. That's where they found the knife. The next photo was in the kitchen area and they found a projectile. The bottom left in 13 is where they found this item. Shell casing. They can find that. They can find a phone. We found the Roomba. That was in the worst area of the fire. Not in the basement, but in the foyer, I believe. Why would it be ringing? And why wouldn't Jennifer call 911? Is it because there's a second person in the house at the time that Keith is outside? And where is the Ring doorbell camera from 15 Willowbrook? Now, I know we heard testimony from Detective Petrozello. He said he got a warrant for the information and he didn't receive anything from the front camera. And I asked him, well, did you follow up? Like, what do you mean you didn't receive it? Is it that it doesn't exist? Is it they missed something, they didn't send it? I mean, did you follow up? And the answer was no. You received what you received. Okay, I mean, doesn't hurt to follow up. Detective Petrozello, again, he stated he followed the evidence. Yes, he did. There is evidence in this case. And the evidence does point to Paul because it's at his home. But did the police ever hypothesize whether someone else put it there? What did they do to rule out that theory? Because you have a man that I submit has no motive. You have a man who loved his family. And you have information missing. So why not try to rule out the theory that there's two people? Because there's certainly evidence to support it. Why not try to rule out the theory of whether someone else put this evidence there so that it would be found? Why not rule that out? Detective Petrozello didn't rule anything out. He was very clear about that. He simply followed the evidence that fell on his lap. Now the arsons, they're not contested. Of course they're arsons. Now, what matters is the timeline. The timelines I went over earlier. And what matters is how did it start and who started it. Again, this is the timeline from 15 Willowbrook. And 6 minutes, it's not a lot of time to do everything that the state alleges one man did, as far as cutting a cable and starting a fire and somehow getting across this large property to a vehicle, not parked in the driveway, but somewhere else, and somehow manages to get home without blood in the car. It just doesn't make sense. Now the ballistics, the gun that is alleged to be used here is a 6-hour P228. It's S193. And what's interesting about that gun is that it doesn't have rails. You heard Detective Sergeant Clayton testify to mount a laser sight. It's also not alleged to have been used with the silencer. The prosecutor asked that question of Detective Sergeant Clayton. Are you saying the silencer was used? No, I'm not saying that. And Mr. Murray followed up and said, well, because the markings don't match? Yeah, that's right. Because they were able to, through the ballistics, match tool markings with the barrel and the receiver, but not the silencer. You didn't hear testimony about that the silencer tool marks matched. Which also kind of makes sense if Dennis Kapora, who you heard lived approximately 2.5 or 3 miles away, heard the gunshots, because a silencer with subsonic bullets may not have reached that far. We also know that Paul owned a 1911 .45 caliber pistol. This is an unregistered firearm with no serial number. It's S189. And he also owned a second 6-hour P228, which was found in his bedroom. Now that gun does have rails, which means you can use a laser sight with it. Which means if someone was trying to shoot Keith in the dark outside, that might be a better gun to use. The barrel also fit that gun. So if the allegation is that Paul wanted to switch out the barrels, that's another option. It also could have been used with a silencer. And the reason I'm saying this is because truly, we submit the fact that Paul Caneiro owns guns and is a gun owner is of no moment. But it's being used in this case to demonstrate opportunity and means. And I suspect they're going to argue that because Paul owns guns and has access to them, this makes sense. But if Paul has access to his own guns, wouldn't he use the one that works with a laser sight? And wouldn't he bring ammunition? Enough ammunition? And if the state tries to argue, well, maybe the gun jammed, maybe that's what happened, well then wouldn't Mr. Caneiro, with all of his knowledge and gunsmith, be able to unjam the gun? The other interesting thing is in the backpack that you heard testimony, people know Mr. Caneiro carries with him. Katie testified that Mr. Caneiro, it's like an extension of his wallet, and he's carried it around for the last 10 years. Another one of our witnesses also was aware of that Mr. Caneiro typically had the bag, typically kept it in the car. So people who know Mr. Caneiro know this is his bag. In that bag, they found a silencer. The silencer that is not alleged to be used. In that bag, they found a FLIR, which is the thermal imaging application that you plug into a phone. We heard testimony that Mr. Caneiro's phone was at his home the entire night, plugged in. They even contacted the FBI to try to make sure, beyond just a normal extraction. And the FBI confirmed his phone was at home. So why would Mr. Caneiro go to a crime scene to commit crimes that he has no motive for, and bring things with him that he can't even use? He's bringing a thermal device he can't use with his phone because it's at home. The silencer that the issue with the silencer, I forgot to mention, Detective Clayton testified, is the silencer with the PT2, the alleged murder weapon, it blocks the sights. That was the issue with the silencer. So you can't, if you wanted to use the sights of the gun, which you would need, you can't use it with the silencer. And that is something which just doesn't make sense. Those are images of the 3 guns. The one in the top left is the unregistered firearm. And those 2 are the 6 hours. Now I'm going to talk about the DNA. DNA it sounds compelling. And I mentioned this in my opening. It does. It sounds very compelling. When you think of DNA, you think, oh yeah, that's a sure thing. But in this case, it's a little bit different. And it's different for 2 reasons. The first is contamination and transfer, okay? The items that were tested, many of the items, the jeans, the gloves, the shirts, the scarf, they came from this pile. Okay, this is taken with this, that's the fire hose. And remember, Detective Catalona testified that when he went in the basement, there were 4 inches of water on the floor, covering that mess. And the lab confirmed, and Detective Catalona said it was paper bagged, and it was brought upstairs, and it was eventually put in the driveway so that it could maybe thaw, because it was melted together from the fire, it was frozen together from the fire suppression water that froze it, and then it congealed. It's like simultaneously melted and simultaneously frozen, and the lab received it wet. So you also heard testimony. Put that aside for a moment and compare that with the testimony you heard, the extent to which any crime scene forensic person, such as Detective Catalona, Detective Vogt, they're constantly changing their gloves. They explained that on the stand. Why? To avoid contamination. Because if you touch one item with a glove and then touch another item with that same glove, that is potential contamination. You want to avoid that. And then you heard the excruciating procedures of the DNA lab. You heard they have secure facilities and hair nets and goggles or masks, and they have coats. Of course, they wear gloves, and they clean their stations in between each testing with bleach or ethanol. They cover it with different paper. They want to make sure that there is absolutely no ability to contaminate what they're testing. There was testimony that, there's contamination by touch and transfer. There's contamination potentially by breathing. That's how sensitive DNA is. And you heard testimony that the DNA kits, the instruments that they use, they're highly sensitive. I think it was either expert witness Christine Schlenker or Reed that testified, we're talking like 20 picograms is how sensitive these DNA instruments are. So imagine if DNA transfer is that sensitive. Those are the precautions that you would take, that anyone would take to prevent transfer and contamination. Imagine what is happening here, where everything is piled on top of itself, melted, congealed, wet. You heard testimony that the DNA actually transfers easier when it's wet with the water. It's a mechanism of transfer. And let's not forget that this is in Paul's house. This is in Paul's basement. Mr. Murray asked the DNA expert, would you expect DNA, your own DNA, to be in your house? Of course. Would you expect a stranger's DNA to be in your house? Probably not. So, whatever DNA of Paul's is found in these items is really much ado about nothing. Because if his DNA is on those items, it could be transferred, it could be contaminated, and it's in his home. And the DNA that matters in this case, the DNA that belongs to Sophia and Jesse, that's the DNA that's compelling. That DNA, the major profile, the blood on the genes, we're not contesting that. But who put it there? Who put it there? Because the mere fact that Sophia's blood is on these genes and they're found in Paul's basement doesn't tell you that Paul put them there. Right? The DNA experts are very clear about that. We don't say how it got there. We don't say why, and we don't say who, because we don't know. We just know that it's there. These were some other images of these items and how combined they are. That's another close-up view. I would call it DNA soup. Because that appears to be what it is. Now the next issue with the DNA. So the first issue with the reliability of the DNA, when I say reliability, I really just mean more colloquially, can you rely on this DNA evidence to say that this man is guilty? The reliability of that is called into question by the transfer and the contamination I just mentioned. And it is also called into question with the fact that when they used the StarMix software for certain samples, they did not test anyone else's DNA against it other than Jennifer, Jesse, Sophia, Keith, and Paul. So I know it's a lot of information, but when we look at EO7A1, for example, the analyst, the number 2 is circled because that's how many contributors there are, right? There's two contributors to that sample. But when you go across the chart, every single person has a likelihood ratio. How does that happen? The DNA experts explained that when you're dealing with StarMix and likelihood ratios, you're simply asking one question. Technically 2 questions. You're asking the software to compare 2 hypotheses. Hypothesis 1, this person, whether it's if you're focusing on Jennifer, Jesse, Sophia, Keith, or Paul, one person at a time. What is the likelihood of this hypothesis, that this person's DNA is in this mixture, versus the likelihood that it is not? That's all it is. It's not whose DNA is in this. It's what is the likelihood that Jennifer Caneiro's DNA is in that mixture versus it not being in that mixture. And based on the information that it had, the data, the alleles, the electropherograms, the likelihood that it was in the mixture is 2.6 thousand. Moderate support. When you do the same thing for Jesse, it's 85. Limited support. When you do the same thing for Sophia, it's 48 billion. Much higher number. And when you do it for Keith, it's 9,000, which is a higher number than for Paul, 1.9 thousand. But both moderate support according to their verbal scale. Why does this matter? Because we don't have, for example, Corey's DNA. We don't know what the number would be for any of these without Corey's DNA. Corey is a family member. He shares a lot of alleles, at least 50%, possibly more, possibly closer to 70%, like Keith and Paul. We just don't have answers to questions that aren't asked. And as you can see, when we have a number like this, 21,000, or 400,000, or 43,000, or even 200 million, or compared to sextillion and septillion, what if someone else has a higher number? What if you asked it, does John Smith, Jane Doe, Paul Caneiro, what if you asked it what that hypothesis? Would the number be higher than 200 million? Would the number be higher than 21,000? Again, we just don't know, and that's the problem. And that's why this information is not a reliable source to convict Mr. Caneiro. It doesn't say, this information here doesn't say that Paul's DNA is in a mixture. It simply says this is the likelihood that it could be in this mixture or that it is in this mixture compared with the likelihood that it is not. And that is very different than random match probability. But this is the DNA that we're focused on. And you saw from the deconvolution reports that I went through with the expert witness, Ms. Reed, there's a lot of information missing. I won't do it again. But when we went through page by page, if you recall, we were going line by line, and StarMix comes up with probabilities for each allele. And there were times where Paul's alleles were like 3% likely, or number 4 down. Sometimes they're first, sometimes they're second, but other times they're at the bottom. And so what does that mean? It's probabilistic. It's using a mathematical model to guesstimate and give you its best guess. It's not a certainty. We're missing information, ladies and gentlemen. And that is a reasonable doubt. That alone is a reasonable doubt. Now, at 15 Willowbrook, there were 4 DNA samples that were taken, that were testified to. These are them. You were shown photos. They're areas of blood located in the general kitchen area. They took these samples in February of 2020. Why over a year later? I don't know. But why so long after, and why only here? I mean, wouldn't we want more information? Wouldn't we want to swab more locations? Wouldn't we want to swab sooner? Wouldn't we want to swab the open door the day that this happened or shortly thereafter? Maybe the unlocked door? Anywhere else in the house? Of course Paul's DNA is going to be at his house. But what about 15 Willowbrook? Whose DNA is there? Not just Paul's, but whose? We don't know what we don't ask. I think this was Officer Mazzicola who identified on this photo which door was open and which door was unlocked. That might have been a good place to start. Now, I also want to mention that Paul was cooperative with the investigation. He cooperated with 7 different investigating officers that day. He spoke to Officer Marino. And Officer Marino asked him, did you guys inhale smoke or anything like your chest? Do you want an ambulance here? And Paul volunteers. I hit my hand somehow. He's rushing out of the house. Katie recalls hearing it. Marino says, do you want an ambulance to come check you out? Paul says, what do you think? Officer Marino says, it's up to you. Paul's not hiding anything. He's cooperating. He's offering up information. Information that I suspect is now being used against him to suggest he's guilty of something. And you saw the injuries, alleged injuries, you saw them. A bruise on the toe or something, a mark on the arm. There's some additional, there's no expert that's testifying as to the age of the bruising. We don't know how that bruising got there. It's nothing that is clearly fresh and compelling as far as injuries. You heard testimony that Paul Caneiro was interviewed. He wasn't asked to take off his shirt. We don't know what, if any, injuries he had. We just don't know. Paul spoke with Officer Redman. He spoke with Officer Bernhard. He spoke with Detective Brady. He spoke with Detective Weisbrot. He spoke with, it actually should say Fire Marshal Flanagan, not Detective Flanagan. It's two Flanagans. And he signed over consent to search his vehicle. He signed over consent to search his DVR. If Paul had something to hide, why would he be so cooperative? And he reported to the police station despite wanting time to change and get cleaned up, change his clothes. He still went. They said, no, you really need to come now. They went, including Paul. He didn't leave. Could have left. I mean, Katie and Marissa left. They went to go get bagels. They came back. Marissa went to her boyfriend's house to bring the dogs there. Then she met them at the police station. He didn't leave, he stayed with his family. And then he went to the police station when he was asked. There's zero investigation into the third brother. We don't have his DNA. We don't have a phone extraction. But interestingly enough, we do have Elise's phone extraction. You heard testimony about that. And first I tried to ask Detective Miglerisi about it, because he did the extractions for Paul and for Keith. And I think he said something to the effect of, I only focused on these. I said, okay. Detective Petrosello might be the person. He's the lead detective who reviewed the extractions. Okay. So I asked him. I asked him specifically about Elise's phone extraction. He said, I only looked at the 19th and 20th. I didn't look at the rest. Elisa is Corey's wife. You're telling me you have this phone in your possession? You're telling me, in light of everything that you can learn from a phone, content of text messages, calls, calendars, data, notes, applications, the list goes on, all of the information that is available to you, law enforcement, for 7+ years, and you don't even look at it? You just say, oh, I just looked at 2 days because I, law enforcement, decided that's what was relevant? How do you rule things out when you decide what to look at? There's vast information available, and no one looked at it. Didn't get surveillance footage from the area of Corey's house. Didn't investigate his finances. Detective Petrosello said he had no information. But he also said he didn't look at the phone. Didn't investigate Corey's knowledge of the trust. Wouldn't we want to know? Wouldn't we want to know what Corey's knowledge of the trust is? We know he knew about it because we know that Keith had forwarded certain emails to Corey, emails between Paul and Keith discussing the trust. Those were forwarded to Corey. So Corey had knowledge of at least we know, he had knowledge of the trust and he had knowledge of what was happening with Paul and Keith in the trust. You also heard testimony that after Keith spoke to Paul on the phone on November 19th, that evening and said, Paul, wake up, I want the login, that his very next call was to Corey. And they didn't investigate his claim that he couldn't drive at night. You heard testimony that he told the detectives, I can't meet you in Monmouth County because I can't drive at night, I have an issue. But you also heard testimony from Paul Caneiro that he arrived on scene at Paul's house at around 6:15 in the morning. Still dark. You heard testimony from the officers that it was dark, it's November, for at least a couple hours. 5 to 7-ish, maybe? Courtney's driving in the dark. So what are we doing with that? Ladies and gentlemen, it is the state's burden in this case. The state's burden. They have to prove their case to all of you. We don't have a burden. That's why we have the presumption of innocence. You might recall my story about the presumption of innocence, but it's very important. Because in our justice system, we do not require any person to try to prove their innocence. It can be a very difficult thing to do. We require the state, we hold them to their burden, and they have to prove their case beyond a reasonable doubt. So if there's anyone in this case that you wanted to hear from, if there's any information that you feel that you needed or wanted or would rely on in coming to a decision but you don't have it, you just have to look to the state. It's their burden. And in this case, in light of everything we talked about, let's just remember that the level of involvement of law enforcement in this case. We have the Ocean Township Police Department. We have patrol officers. We have detectives. We have the Colts Neck Police Department. We have patrol officers. We have detectives. We have the Monmouth County Prosecutor's Office. We have a variety of detectives in a variety of different fields. We have the Monmouth County Sheriff's Department. We have the New Jersey State Police. We have the FBI and the ATF. We also have Asbury Park. Detective Brady, Detective Zarillo, Detective Weisbrot, Detective Mahoney, Detective Catalona, Detective Vogt, Detective Bassender, Detective Cordoma, Detective Wayne Rayner, Detective Kevin Condon, Detective Andrea Tozzi, Detective John Sostian, Lieutenant Mueller, Detective Robert Flanagan, Detective Scott Valenti, Detective Sean Murphy, Deputy Chief Wilbert, Detective Nareth, Detective David Sidorakis, Detective Kristen DeVito, Detective William Anton, Richard Shin, and Jose Cruz, and a name I can't pronounce, and Scott Samus. I think I asked Petrozello, are these all the detectives that to your knowledge are involved in this case? I gave him that same list, and I think to most of them he's acknowledged yes. All of that, all of these resources, you can't look at a phone extraction? Longer than 2 days? You can't get someone's DNA who's related to this family? You can't investigate more? You can't do all of the things that I just mentioned? Traditional investigation? Outside of the science? That's what they're relying on here. It's not enough. It's not enough. These are the reasonable doubts that I mentioned. These are the main categories. There are subcategories I went through a lot. And this is a non-exhaustive list. It's not, there could be more. This is what I'm presenting to all of you. And if there is any reason to doubt in this case, you don't need to find all of these to be reasonable doubts, you just need to find one. That's what our system requires. I just thought of another one. Why was Keith? If Keith is outside of his home, and Paul's phone. There's no evidence of conspiracy with another person. If you find the evidence in this case compelling that there's two people, well, there's no evidence that Paul was involved. All of these facts, all of the missing information, the lack of investigation, the missing evidence, and the remaining questions that have not been answered are reasonable doubts. Now, there's 3 principles of law. I'm almost done. I'm going to sit down soon. We talked about the presumption of innocence. I'm not going to repeat that. We know what that is. I trust every single one of you know what that is. The burden of proof, we talked about that. It's on the state. So the last thing I want to talk about is standard of proof. What does proof beyond a reasonable doubt mean? In our justice system, we have sort of a scale of burdens, of standard of proof. The lowest level is probable cause. Probable cause means there's some evidence. Beyond a reasonable doubt is the highest standard, and it's all the way at the other end. If you find that there's some evidence in this case that Paul Caneiro is responsible for these crimes, you can't find him guilty. You'd have to acquit. Next is preponderance of the evidence. It's used in a lot of civil cases. And it basically just means that instead of being here, equal poise, we're here. It's more likely than not, which could be 51%. And if you find that it is more likely than not that Paul Caneiro is responsible for these crimes, you have to find him not guilty. It's not enough. The next is clear and convincing evidence. Clear and convincing evidence. It's pretty self-explanatory. If you find that there is clear and convincing evidence that Paul Caneiro did this, you cannot find him guilty. You must acquit. It is not enough. If and only if the state can prove its case beyond a reasonable doubt, which means you are so firmly convinced that there is no rational reason left in your mind, rational reason, to doubt. That is the only time that you can find someone guilty. There's a saying that justice is blind. The reason we say justice is blind is because justice is fair, it's impartial, it's objective, and it is blind from bias and prejudice and assumptions and subjectivity. Justice, and sometimes we see the Lady Justice and she's holding the scales. Justice is blind because justice doesn't judge. It weighs. That's why we have the scales. Because in a case like this, where, as I said from the beginning, the allegations are harrowing, in a case like this, we have to be free from judgment. We have to be free from bias. We have to be free from emotion. And we have to just weigh. And I submit to you, ladies and gentlemen, that when you follow your oath as jurors, and you weigh the evidence in this case, and you weigh whether the state has in fact met its burden, whether we're here or here, I submit to you that they have not met its burden. I submit to you that they have not proven their case against Paul Caneiro beyond every all reasonable doubt.
Objection.
Reasonable
That's
doubt.
not, that's not the standard.
That is not the standard. Ladies and gentlemen, I'm going to give you the law as it relates to reasonable doubt. Only if the attorneys want to discuss the law, if it does not comport with what I tell you, it's what the law as I give it to you, not based upon what the attorneys say. Go ahead.
Beyond a reasonable doubt. A doubt. Mr. Caneiro is not guilty. He's innocent.